friends. My name is Kelly O'Brien, and I am the Executive Director of both the Chicago Central Area Committee and the Alliance for Regional Development. We started this webinar series back in March, and it is really a pleasure to be able to get speakers like Mark Rust to help us understand what's in the news and to get our questions answered from real change agents. As a point of reference, Mark has been a member of the Alliance for Regional Development Board for probably over 5 years now, I think, Mark, and you have been an early supporter, and I'm very grateful for that. And I do want to preface our conversation by saying that this is, again, meant to be informational. We are not promoting one side of the issue or not. We just want to make sure that people understand the facts. And with that, I want to make sure that you know that we are happy to have your questions answered. So please use the Q&A button that Zoom provides at the bottom of your screen, and I will do my best to relay your questions and concerns to our speaker today. So if you're not familiar with Mark Rust, he has a very impressive resume. And just very quickly, I'd like to share some of Mark's background. So Mark Rust is a partner with Barnes and Thornburg, again, a major supporter of the Alliance, for which I am very grateful. And Barnes and Thornburg is the nation's 82nd largest law firm, where he serves as vice chair of the firm's management committee. After graduating from Notre Dame, he began his career as an investigative, medical, and legal journalist for 7 years as a reporter in Chicago. Following 4 years of legal studies from Loyola, which of course I too am a Loyola Law School grad, so we share that in common. Mark has been practicing as a healthcare lawyer and has been recognized by the Chambers USA, Top Healthcare Lawyers of Illinois, Illinois Super Lawyers, and the Best Lawyers in America. He is also the immediate past chairman of Chicago's 97-year-old Better Government Association, the BGA. Mark counsels healthcare companies and associations on corporate and regulatory laws. In that capacity, he has entered appearances before the United States Supreme Court on 3 occasions, each of which has ended in victories for his client. One in particular that I would like to highlight is in regard to a startup Illinois insurer called the Land of Lincoln Health, in which Mark and his team fought against the United States government, helping to win a Supreme Court case 8-1 that resulted in a $150 million award for the state of Illinois in payment for a broken promise made to his client by the government under the Affordable Care Act. And it actually established a new law defining that when Congress is required to pay for a promise, even in the absence of appropriation. So that is, really critical, groundbreaking law that Mark has been at the forefront of. In addition to being at the top of Supreme Court cases, he also appears before Congress and several state legislatures, providing testimony on healthcare delivery and managed care, where his experience as a lawyer has been aided by his knowledge of healthcare delivery that he gained as an investigative journalist. So again, welcome, Mark. Thank you for joining us today.
Thank you, Kelly. Good afternoon. And yes, we are going to talk today about California versus Texas, otherwise known affectionately as the Affordable Care Act case this term. It is politically charged, probably for 3 reasons. One is it occurs to us here in the midst of an election. It'll happen, the oral argument will be heard a week after the election. Second, because of the extraordinarily unusual posture of the United States government, normally intervening to uphold the law of the United States, in this case, intervening to literally strike down, asking the court to strike down a law of the United States. And third, obviously, we're in the middle of the replacement of a judge, Justice Ginsburg, oftentimes referred to by the media as a liberal justice, with a judge out of the U.S. Court of Appeals for the 7th Circuit, oftentimes referred to by the media as a conservative justice. So for those people who believe that court cases like these are politics or outcome determinative, they may be lining up their notions of who's conservative and who's liberal, but that's not normally the way I would analyze this case, these cases, and I certainly don't analyze that one in this case. Today, I'm going to share with you what I would be saying to a client who is asking whether they should spend the money and time to get involved in a case, what their likelihood of success would be when they ultimately get before the Supreme Court, or if I was counseling a financial firm who had a lot of money riding on the outcome, just looking at it as a clinical professional matter. To begin with, it's important to recall the history of the Affordable Care Act. It was passed a little bit in a rush after both houses of Congress passed versions of the bill in late 2009. The Democratic House and Senate was going to get together in early 2010 in a conference committee to straighten out the rough edges on the bill and pass it, but Senator Kennedy died. A Republican replaced him in Massachusetts who vowed to vote against it. And as a result, it was passed in a bit of a hurry on March 23rd, 2010, with an amendment that was meant to give solace to House members who didn't get everything that they wanted in the Senate bill. So it was immediately on the same day, on the same hour, an amendment to the Affordable Care Act was passed, extending its 2,400 pages and 10 titles even beyond the act itself, and including a lot of amendatory language. So it was a huge bill. It was immediately attacked by its critics as having statutory and constitutional flaws. And we heard these critics speak in pieces of litigation that reached the Supreme Court. In 2014, for example, in King versus Burwell, the court dealt with a statutory question in the drafting of the statute, which seemed to indicate, the language seemed to indicate that a state chose to participate in a federal exchange rather than an exchange started by a state, would be a state whose citizens could not get subsidies. If the court had ruled that that was the case, that Congress meant to do that, it would have thrown the private markets into chaos. Indeed, the court, by a fairly closely divided margin, decided that it was really a drafting error on the part of Congress, and they saved the statute. The most important case, however, occurred early on, 2 years after the passage of the act, the National Federation of Independent Businesses versus the Secretary of Health, Sebelius. And in that case, there were three issues, and it's important to remember that there were three issues the court was deciding, just like in this case. The first is whether Congress, which when it's exercising its power, must point to the limited power that it has, that it's exercising for its enforcement, whether Congress in enacting a mandate that every citizen buy a policy of insurance, whether that could be upheld under the Commerce Clause. The second question was whether Congress exceeded its spending power when it changed the scope of Medicaid, not in degree, but in kind, and forced all states to adopt a new Medicaid regime, and if they failed to do so, lose all of their Medicaid funding. That was a constitutional attack as well. The third issue was if either of those things were constitutional problems, should the entire statute fall? Is that the remedy? In brief, the court held that there, by 5-4, but by 5 judges said that there was no commerce power to uphold the idea of a mandate. That was not the holding. The holding of the case was the taxing power of the United States could be used to uphold what Congress had done, which is to say, Kelly, you either buy a policy of insurance or you pay a tax of $800. And so they were able to avoid the question of whether the whole statute should fall. And yet we did have that other question. Did Congress exceed its spending authority? In that case, by a 6-3 margin, the Supreme Court said it did. And by a 7-2 margin, it upheld the act by imposing a relatively limited remedy, saying that the notion of a Medicaid expansion in each state will be optional. States could choose it or they could not, and they would still be able to get their traditional amount of funding for Medicaid. They just wouldn't get the extra funding that the government was offering as a carrot to expand Medicaid. So once again, the court, this is now the third time the court showed their willingness to try to not knock down the entire statute. Those facts are important as we consider our current case. Our current case started in 2016 when the Republicans took over the House, the Senate, and the White House. Immediately went to repeal the Affordable Care Act and famously failed to do so. So Congress couldn't repeal the Affordable Care Act. That was the will of the people. Then in 2017, the Republicans did reduce to zero the amount of taxes that was the penalty for failure to purchase a policy of insurance. So today, if you ask me, is it a requirement that I have to buy a policy of insurance? All I could tell you is that the statute says that, Kelly, you must ensure that you have a policy of insurance. But if you don't, there will be no penalty. You don't go to jail, you don't pay a fine, you don't pay a tax. So immediately, the state attorney generals of the Republican states filed suit saying that since there was no longer a tax, the government no longer had a legitimate power to exercise over that mandate, and the mandate has to be declared unconstitutional. They then said, if you declare the mandate unconstitutional, you must strike down the entire statute, because Congress never would have intended to pass this statute if they thought the mandate wasn't going to be part of it. The federal district court judge who heard the case agreed with both those propositions, a federal court in Louisiana. It went to a federal appellate court who said, yes, we agree that the mandate is now unconstitutional, but we question the remedy that you're giving it. We're sending this back down to you to think some more about that, federal judge. How would that exactly work? And right after they sent it back to the federal judge, the state attorney generals from Democratic states asked the Supreme Court to take this question up immediately, whereupon the United States government intervened in a very unusual way to say, we're in favor of the Republican judges. We think this law of the United States should be gutted because the mandate is no longer constitutional. What is before the court now are three issues. One, did the Republican attorney generals have the standing? Are they the proper party to bring a suit like this? It's a very boring issue, but courts are very taken with this, and particularly this recent Supreme Court, the case that you referred to that we won the $150 million on, that was 8-1. The judge who voted in dissent, Justice Alito, didn't disagree with the idea that the government owed the money. His only issue in dissent was our insurance companies the proper parties who had standing to bring that case. So justices are really always concerned about standing. Go ahead.
And Mark, there are probably members watching this that are not lawyers, and they may not understand what standing is. So for those non-lawyers, can you please explain what is standing?
So if I get mad about something, but I'm not really a party to it, and I just want to file suit, I'll be bounced out on my ear immediately because I'm not the proper party to bring the suit. I got mad about a dispute that you were having with someone else. I wasn't involved in it, so I shouldn't be the party who's bringing it. This standing issue arises quite often when the parties are at each other's throat about an act of Congress that they think is not being properly administered. And the question is, who's the right party to bring a suit about that issue? The important thing is that the notion of standing is so fundamental that courts can raise it at any time on their own. Indeed, even if neither party has argued this already, courts could argue on their own, hey, we want to hear arguments on whether you even have standing because we may not hear the rest of it. If the court decides on that issue, it's done.
And so, just to really simplify things, if my neighbors have a fight and let's say the husband hits the wife, I can't sue the husband for hitting his wife because
Correct.
I wasn't hit and I wasn't harmed.
Correct.
So it would have to be the wife that actually files suit against the husband, for that assault.
That's correct. You can pay your legal fees if you want, but you can't be the party who's litigating that. That's correct.
And then I also want to clarify, when you talk about the Republican attorney generals and the Democrat attorney generals, it was the Republican attorney generals led by Texas, right? And I think a total of was it like 19 states, I think,
yes,
that joined suit on that. And then on the Democratic side, it was led by California. And I think there's 21 other states on that side.
correct.
In case people wonder, why is this case called Texas versus California? That's the answer. It's because it was the Texas-led Republican attorney generals really fighting against the Democrat-led attorney generals really trying to get answer around the Affordable Care Act and whether or not it's constitutional. And what you're saying is that the first thing that the court is going to look at is, do these attorney generals even have standing, the ability to be bringing this case in front of these courts?
That's correct. And that is in all the parties. As I mentioned, the United States intervened on behalf of the Republican attorney generals, and the United States House of Representatives intervened on behalf of the state Democrat attorney generals that are also individuals involved in the case. So that'll be the first issue to decide. And it could be that the entire case rises or falls on that. The second issue, which is really at the heart of the matter that many people are very interested in, is this general question of whether the United States government has the power to tell you to purchase something. If they have the power to tell you you must purchase a policy of insurance, do they have the power to tell you you must purchase an American car? Does the commerce power go that far? And as we know, in the National Federation case, 5 justices said it doesn't go that far. They can't force you to do that. But what they can do, said 5 justices, is say if you don't buy an American car, you have to pay a tax. And so there's a zero tax right now. And the question is, with a zero tax, is the tax power the power that you'd still rely on to say the federal government can have this mandate? Or do you have to say, because there's zero tax, there is no power left to uphold a mandate, and therefore that mandate is unconstitutional? That question will be very important, not for healthcare, but for many other purposes in commerce in the future. There's a variety of ways the court could answer that. They could say, yeah, there is no longer a tax, therefore it's unconstitutional under the Commerce Power Clause. They could also say, no, it still is part of the tax code. It's sitting there as a zero tax, but if a Biden administration comes back and Democrats control the Senate, they may want to put an $800 tax back into it, in which case it, once again, the federal government is exercising its correct powers. So I think the chances are good that the Supreme Court probably wants to reach that issue and talk about that issue. But certainly there would be votes there, I think, for the idea that the Commerce Clause cannot force you to purchase a mandate of insurance or any sort of mandatory good. Then the final question, which is the big enchilada that everyone is concerned about. If they were to find that this was unconstitutional, is the appropriate remedy to gut the entire Affordable Care Act? And here I would say the evidence is fairly overwhelming that that is not a likely outcome. And the reason I say that is this. On the side of not gutting the entire Affordable Care Act is the longstanding hesitancy that courts have to strike statutes, particularly the US Supreme Court. They have to think long and hard. Every case starts with a recital of cases saying, we don't normally do this sort of thing. So there's a hesitancy. And in fact, in the past history of this statute, we've seen 3 times the court has kind of gone out of its way to not strike down the statute. The second thing is the last time around that they had that ability to strike down a statute, they didn't do it in National Federation of Business, and they didn't do it even when they found a constitution, they didn't do it in Burwell, in the Burwell case in 14, and they didn't do it even when they found a constitutional flaw in that National Federation of Business. The third is that this act, the first time that this was considered whether to gut the entire act, the act was only 2 years old. The public markets had not started up yet. No one had purchased a policy of insurance. Today it's 10 years old. It affects roughly 1/6 of the economy. It's 2,400 pages, not including the amendments, consisting of 10 titles, 9 of which have absolutely nothing to do with the issues that are being litigated. They have to do with issues like straightening out some of the rules regarding anti-kickback and anti-self-referral laws, creating a mechanism for fair reviews of medical procedures, putting more money into technology, changing reimbursement rules for ancillary medical procedures, all kinds of things that have nothing to do with what we're talking about today.
Well, and in fact, if anybody ever goes to a drive-through at McDonald's as an example, the reason that we now see the calorie count when we're trying to decide between a small fry and a large French fry is all because the ACA requires that kind of label, nutrition labeling, correct?
That's right. That's exactly right. So finally, I'd like to say before we take questions, the sole argument on the other side that the Republicans, the United States government is arguing is legislative intent. It never would have been Congress's intent to have this act go into effect if they thought the mandate wasn't going to be there. Now, interestingly enough, Judge Barrett, who has been repeatedly in the press, it's been mentioned that she was, quote, against the Affordable Care Act. What they're actually referring to is a Minnesota Law Review article in which she cast doubt on Justice Roberts' ability to uphold the mandate under the taxation clause of the powers of the federal government. She did not answer the question whether she thought the commerce power would do it. She also certainly didn't answer the question whether she thought that the remedy should be to throw it all out. And interestingly enough, the main argument that is being used by the Republicans now is exactly the type of statutory interpretation that Judge Barrett is famous for not liking, which is legislative intent. In fact, that law review article was primarily about the objecting to legislative intent, and instead the question of how do you do a strict construction of a statute when you're trying to determine its legitimacy. So with that, I'll stop and take some questions.
Well, Mark, on that note, the one thing that I found very curious is my understanding is that Justice Scalia took a dissenting opinion in the NFIB case, and that he believed that the mandate was inseparable from the rest of the ACA and the entire law should fail. And as we know, Amy Coney Barrett, was a clerk to Justice Scalia, and it's my understanding too that she did have a review with Professor Randy Barnett, who's considered one of the chief architects of the critiques of the ACA, and that there is that. I think that's one of the reasons that people are concerned that Amy Coney Barrett will line up more with, Justice Scalia's writings, and that.
Yes. So that law review article that I just mentioned is the one in which she was basically reviewing.
It looks like Mark, you froze for us. Hopefully the technology will come back. As we wait for Mark, I think that it's important to point out that I know a lot of these dates can be very confusing, and a lot of these cases. And just to again kind of reiterate what Mark said, the Affordable Care Act was first passed in 2010. And then it was 2017 with the Republican Congress that the Tax Cuts and Jobs Act was enacted, basically zeroing out that penalty if we did not purchase healthcare, which, as you may remember from when getting your taxes done, we would be asked for some kind of verification that we had insurance. So when the Tax Cuts and Jobs Act was passed, it eliminated the penalty for not having any kind of health insurance. So in 2012, when this case that Mark was talking about with Sebelius, that was really, a very important case as it dealt with so many of the issues that are important to the Affordable Care Act. But really what we're talking about now and what's going to happen on November 10th, which is a very important day, because please remember that the Supreme Court just started their new session yesterday, October 5th, and that this case is going to be heard on November 10th. So it's coming up right around the corner. And one of the other, I think, important points that Mark had alluded to, and I'm sure that he is probably feverishly trying to dial back in, and I'm sure he'll pop up on screen any moment now. But in terms of the US government, what Mark was saying is so unusual is that the Department of Justice was actually going against a law of the United States, the Affordable Care Act. And in June of 2018, the Department of Justice argued that they felt that by virtue of this one part of the law, the whole idea of mandates of being the government is not able to tell us to buy something. They can tax us, but they can't force us to buy something. And because the Affordable Care Act was written in a way that it is telling us to buy something, it was not written in a way that it was a tax, that then the whole law, all, 2,000 some pages, should all just go away. Where many laws and many contracts that we deal with every single day, there's what they call that severability clause, which basically says if one part of this is broken, it doesn't mean that you throw the baby out with the bathwater. And that's really important because the ACA did not address that. And that's one of the really big issues. And as Mark said, when the Supreme Court, if they do have a ruling, that is going to not only affect the ACA, but so many of our laws that are, it's almost unimaginable how that will affect so many other pending legal cases. So when the DOJ in 2018 started arguing that the entire ACA should be found unconstitutional, and that they were unwilling to advocate for the provisions such as protecting pre-existing conditions. And I do think that that is probably one of the reasons why Speaker Nancy Pelosi, is quoted as saying that President Trump does not want to crush the virus, but he does want to crush the Affordable Care Act, because the US Department of Justice has not only argued once, but they've argued twice that the ACA should be found unconstitutional. So this is something that is, as you can imagine, very politically charged. And I think a lot of people are very confused. I think they're confused. How did we get here? Who is arguing this? What have all of these cases meant to date? What does it mean if there is only 8 justices? And in terms of the case that Mark was referencing with in the Fifth Court, I think it's important to remember that Mark has joined us. Okay. So Mark, I was just talking about kind of what was happening on the local level and with Judge O'Connor, and that he really ruled that without the mandate, the whole ACA should be found unconstitutional. And it was surprising when the Fifth Court did not just wholly say that was right or wrong. They sent it back to that court. And then that's when California got involved and said, we want to try to get this escalated to the Supreme Court. This cannot continue to be on this local level, kind of going back and forth on all of these different issues, leaving so many people feeling so uncertain in terms of what kind of health insurance is available to them. And as Mark suggested, the markets and the exchange and this incredible healthcare structure that has been created over the last 10 years.
I'm back, Kelly, if you can hear me.
So we can hear Mark, and I'm going to ask the audience, if you have any questions, to please submit them through the Q&A button. So Mark, one of the questions that has been submitted reads, is the fact that the Congress in 2017 zeroed out the penalty, but left the rest of the law to stand, proof of Congress's intent that the penalty may be severable? And what about the fact that the ACA has functioned without a penalty for 3 years, showing that the penalty was effectively severable?
Very sophisticated question. I would agree to both propositions. I think that's likely where the where the court is likely to come out. Congress had it well within its power to do whatever fixing it wished to do. It zeroed out the penalty and leaving in place the possibility that they might put the penalty back in the future, but they severed it themselves. They did their own job. You could almost hear the Supreme Court writing that that they did this job for themselves. They already figured this out. If they wanted to say, hold it, it's sort of like shooting yourself in the foot. If you really think that this act can't possibly work, if we don't really mandate people to buy insurance, you aren't helping yourself if you zero it out. They effectively used the power of the people to engage in whatever they wanted to do, which is taking away effectively the mandate. And the fact that it's been going for, yes, now going on 3 years proves that the fact that there is no mandate doesn't ruin the statute. So I think that that's a very insightful question. I would agree with the proposition.
You know, it is 2 o'clock and our webinars generally only run 30 minutes, but because Mark, we did have that technology issue, I'm going to ask if you'd stay on for just a few more minutes and ask our audience to please stay with us and submit any questions that you may have. Mark, another question is in regard to the legislative intent and any thoughts as to why Congress left this open. Why didn't they address severability back in 2010?
Well, actually, interestingly, this is exactly the reason why Judge Barrett and others question the value of legislative intent, because it's really hard to read into the intent of essentially 465 people. All that we know is what they actually did. What they actually did is they tried to repeal the entire act. They could not get that done. What they actually did was zero out the penalty. So effectively, they took out the mandate. In fact, that's what most of the Congress.
Well, it looks like our technology issues are persisting. So with that, I want to thank the audience for joining us today. If you have any
Took away the
additional
mandate
questions.
and let the rest of the thing stand. So it must have been their desire to let the entire act stand except for the mandate, which makes sense.
Thank you, Mark. Unfortunately, you did cut out for a little bit there. So I think that I'll ask one last question for those that are remaining, although I had started to close the session. But you were making some very strong points as to why the ACA should stand. But if you were arguing on the other side, why it should be found unconstitutional, what would you say is the strongest argument why the court could in fact find it unconstitutional?
Well, I think that the idea of finding the mandate unconstitutional, there are some very strong ideas that Congress does not have the power to simply mandate you to purchase something. They do have the power to tax you if you fail to purchase something that they think you should pay. That was the holding of National Federation. The question of remedy is one that is, frankly, you would expect the very best argument to come from the United States Solicitor General's office. They do this for a living. And their argument wasn't terribly persuasive. It was a very long argument about legislative history and about legislative intent and all the practical reasons why there's problems with this statute without the penalty. But as your previous questioner pointed out, there hasn't been a mandate in place for 2 years and the sky hasn't fallen. And Congress is in charge of this policy, and they've had a few years to deal with it, and they've dealt with it the way they've dealt with it, which is to zero out the mandate and leave the rest in place. Pre-existing conditions protected, public markets continue to sell their policies. People can cry about whether those policies are more expensive than they'd like them to be, but they still exist, and subsidies are being used to pay for those policies. So the best you can come up with is what the Solicitor General did come up with, and that is legislative intent. But ironically, that's exactly the issue that Judge Barrett is very opposed to in reviewing statutes. Don't show me what the legislative history says or read into this. Just tell me what Congress did. That's the best example of what Congress intended.
Well, thank you, Mark. I know, again, oral arguments are November 10th. We'd love to invite you back to the webinar series and help us understand after November 10th, early next year, what happens next, and help the American public really deal with whatever the Congress does ultimately, or I'm sorry, whatever the Supreme Court does ultimately conclude. So with that, Mark, thank you for joining us. I'm sorry we had these technology issues. I do look forward to having you back. And for the audience, I look forward to having you back on Thursday at 1:30 when we will have the pleasure of our Illinois State Comptroller talking about fiscal issues and particularly how Illinois' budget has been impacted by COVID. So please watch your emails, register for that. Stay well, stay strong. Thank you for joining us today, and I look forward to seeing you Thursday. Bye, Mark. Thanks so much. Bye,
Thank you,
everybody.
Sally.
Have
Bye.
a great day. Stay well.
Thank you.